Attendees are in listen-only mode.
So, good afternoon and welcome to the first in a series of webinars which are going to focus on expat tax and global mobility issues. The webinar today will be presented by myself, Sarah Robert, and Charlotte Firth, and we both work for UTN UK. Just to give a bit of background on United Tax Network, you can find more information on the website you'll see at the bottom of the slides, but this is a network which is specifically for global mobility and expatriate tax. There are contacts in 110 countries, and each country specialises in international global mobility, so helping companies moving their employees around the world. The core services that UTN offers can be found on the website, but we'll just run through those quickly now. We can help with assignment services, so planning your assignees and their moves overseas. We look at tax and social security as part of that planning, making sure that you are compliant as employer and your employees are also compliant. We can help with equity rewards. If you're going to be giving somebody stock options, restricted stock units, or other types of arrangements, we can look at the cross-border issues related to that. And we make sure, as I said, you are compliant, your employees are also compliant, both home and host countries. And we assist with payroll. We can do payroll consulting, advising on what payrolls need to be set up, what needs to go on payroll, and also running the payrolls themselves. So today's topic is remote working overseas, and I should just say that you do have the ability as we go through this presentation to ask questions on screen, and whatever questions come up we will answer them at the end of our presentation. So the fact pattern we've put up here is as follows. We have a UK employer with an employee moving overseas. It may be that the employee is a foreign national moving back home. It could be that that person has a spouse moving on assignment, so they want to naturally move with their spouse, or it may just be somebody looking to move to Spain for a warmer climate, and we have seen all of those examples. But this is a good employee. The UK employer wants to keep them. The employee wants to remain as an employee of the UK company. They've built up their time there and they enjoy their career. And the suggestion is that this employee will just basically work from home overseas once they've moved. And the UK company generally doesn't have an entity in the host location. Otherwise, it would be easy to set them up on local payroll, etc. So a lot of clients come to us with this scenario and say to us, okay, basically we're just going to be changing the individual's address in our HR system. Is that all we need to think about? However, the issues that need to be considered are, as on this slide, there are several things that you need to work through before you can sign off, and my colleague Charlotte will now go through those issues in more detail.
So the first issue that a company should consider before going ahead with a remote working agreement is permanent establishment, and whether the employee is creating a permanent establishment for the UK company in the other country that they're going to. This in practice can depend on the particular circumstances and the type of activity the employee will be carrying out. For example, if it's just an employee working from home, then the risk is relatively low. However, if they will be entering into contract negotiations on behalf of the business, then the risk is much higher. The position might also change with time. For example, if a home worker then ends up hiring other employees in the other country, work increases and maybe an office is set up, then the risk increases as well. And if a permanent establishment is created in the other country, then there may be a corporation tax liability there and the requirement to register with the local tax authorities. So for those reasons, it's important to undertake a review with a local advisor before going ahead. The second point to consider is income tax withholding. The employee is likely, if not initially at some point, to become tax resident in the host country. And some countries would require a payroll to be set up locally, with tax withheld and paid over to the local tax authorities. There can also be an ongoing UK tax liability if the individual is returning to the UK and carrying out some work duties there, so that's another point to consider. The third issue to consider is social security. The company should understand the social security position both for the employee and for themselves as employers in advance. For example, if the individual is working in another EU country and also in their home country for more than 25% of the time, then the social security liability is likely to fall to the other country rather than the UK. For that reason, it's important to understand the social security rates in that other country, as this can vary quite a lot. In many cases, it might be cheaper than in the UK, but in many other cases, it's more expensive. An example of that would be France, where employer contributions can be up to 40% of gross salary, which compared to 13.8% in the UK is quite a big difference. Along with the rates themselves, you should also consider registration requirements in that country, whether a payroll is required for social security contributions to be withheld and paid over, and whether other forms require completion, such as A1 or social certificate of coverage certificate applications. So that's another reason that should be looked at in advance. The next point to consider is employment law. Although the employee may no longer be under UK jurisdiction, it's important to ensure that the UK terms of contract are aligned with the requirements in the host country, and that will cover things like holiday entitlement and working hours. It may also be necessary to create a working from home policy to cover health and safety provisions and make sure they're adhered to. Although in this scenario the employer is keen to retain the employee working overseas, it should also consider the cost of termination in case that's something that is required in the future, and that can be quite a higher cost in some overseas countries. The final key issue to consider is directors, including non-executive directors, in this scenario who are non-UK resident and get fees for director work in the UK. This is quite a complex area because directors often have many other roles and responsibilities in various countries. For example, they could be considered an employee in another country as a result of their work, or their work could be considered self-employed. The EU rules for social security often prioritise employment over self-employment, so the director could be considered to come under UK social security legislation for all of their roles, not just the UK directorship. So for that reason, it's important to have a conversation with the director in advance and find out exactly what they're doing in what country.
Thank you, Charlotte. We're now going to just do a quick survey on the screen to see where you have most of your workers who are working outside of the UK. So you should now see a poll which is giving you the various places that you can tick: Europe, Asia, Americas, etc. So we can just leave you a couple of minutes to fill in that poll. Okay, so we're going to close that now. Thank you for responding, and we can see here that the majority of you have people working remotely in Europe. That's a good thing because the next two client cases that we're going to be looking at are both European cases. So these are live examples of clients we've helped where they've had remote workers in two different European countries, one Sweden, the other in France. So in the first case, we had a Swedish national working for a UK employer, very good worker. UK wanted him to stay as an employee. He just wanted to move back to Sweden. So they came to us for advance advice, and we managed to give them that advice and sort out the issues for Sweden as follows. First of all, From the work the individual was doing, it was confirmed locally that he was not going to create a permanent establishment in Sweden, so we could tick the permanent establishment off. In terms of social security and income tax withholding, there wasn't going to be any income tax withholding, even though the individual became Swedish resident more or less immediately, because the tax was going to be covered in his personal tax return at the end of each tax year. But for social security, he was required to pay Swedish social security, and that became a contribution liability not only for him, but for his employer as well. However, the Swedish authorities said that he could register for and would be responsible for the social security payments for both employee and employer, given that the employer was a UK employer and not present in Sweden. So the UK company every month made a payment of his salary, calculated their Swedish social security contributions, paid him gross plus the contributions, and he made the payment of social security to the Swedish authorities. The company sent the employment contract to a local lawyer who made sure that it was compliant in Sweden for things like holiday, etc., and therefore that was also signed off. We then turned to a second case, France, where unfortunately nothing was done for the first 4 years for an employee of a UK company who had moved out to France because her husband was assigned there by his company. She carried on working for the UK company, and after 4 years decided she really needed to sort out her health registration in France, and applied for her health number in the local country, at which point the French authorities asked what was happening for social security. So up to that date, the UK company had continued to pay UK national insurance and hadn't really done much else. So we managed to obtain an A1 certificate to keep her in the UK system for the first 2 years, and we had to make a refund claim for the following 2 years when she'd continued to pay UK national insurance and the company had paid as well. So we got the refund back, but then the company had to register in France for both employee and employer contributions from year 3 onwards and prepare a French payroll on a monthly basis and pay over the French social contributions. And as Charlotte said previously, it was a bit of a shock because those contributions for the employer were at 40% compared to the UK 13.8%. There was no requirement for income tax withholding, as France currently doesn't have withholding on salary for French residents. However, that is all going to change as of 2019. In between doing all of this work, the employee became pregnant, which then put pressure on for making sure she was covered from a health perspective under the French system. And we also then had to look at the EU rules as to where she was entitled to maternity pay, because the differential between the UK and France was quite substantial. So that was an additional complication that we had to sort out.
So you can see from these examples that sometimes the position is more straightforward than others. We also often find that the business is unaware of someone working remotely overseas until after the event, because perhaps a manager in a particular department has just agreed it without reporting to the business as a whole. We often also sometimes see the reverse position. For example, when a husband is on a formal assignment to the UK from overseas, and the wife, who might work in the same company, has accompanied him here and is just working from home. So there can be different permutations.
Now, that ends our presentation for today. I don't see any questions on the screen, and therefore I hope you've enjoyed the presentation. If you do think of anything else and you would like to ask a question, you have our details, our contact details now on the screen. Please feel free to email us and we'd be happy to assist you. Last thing, then, just wanted to advise that the next webinar we're doing is on the 30th of April, and this will focus on UK inbounds and tax planning around overseas workday relief. Thank you.